So, welcome everyone. We are glad that you are choosing to spend some time with us. Today, we are doing a parent to parent, parent to professional, procedural safeguards presentation. We're super excited. This is our first time giving this particular slide deck. We have made some changes, which I'll talk about in a couple of seconds, not to the procedural safeguards, of course, just to our presentation about them. So Joe, next slide, please, so we can give a heads up on what to expect. So first, my name is Maura Albritton. I am assisted today by my colleague Joe Goyos, who is managing quite a bit of technology, and then also our Spanish language interpreter, Mario Garcia. And we are going to do some quick introductions. We are going to then just a brief acronym review, some big ideas, and then we're going to hit those procedural safeguards in a way that I think will be unlike what you are used to seeing. We then have 6 parent-to-parent tips to take away and some resources to share. Then we are going to stop the recording. We're going to just cover a brief number of upcoming events in the community that we hope you'll share with folks that you know. And then we will, time permitting, make our way through questions and answers. Today, I am hoping that you will utilize the chat feature, just again, so that we can capture a good recording. I am going to proceed through the slides. Joe will monitor the chat, so if there's a question, an acronym, something you didn't catch, just stay tuned. Hopefully someone can catch you up. Otherwise, we can go to the next slide. So one piece of housekeeping is that we are funded through a grant and our grant funders would like us to collect data about how valuable you found this presentation. So we will launch a survey toward the end, and we will also follow it up with the slide deck in its both in Spanish and in English. And we want to just acknowledge up front, this is a unique format. You will see it does not go page by page through the procedural safeguards. Instead, we have changed it to align with all of our workshops to really make a point of, for families, reinforcing the IEP process. So really putting those procedural safeguards in the order to which a family would typically need to use them. We also come with a unique perspective. So I am a parent. I have 5 children, all of whom had disabilities. 4 have had IEPs, 2 have had 504 plans. So I very much cannot divorce myself from my personal experiences. However, Exceptional Family Resource Center also has lots of positive relationships with our educational partners in both San Diego and Imperial counties. So we really do bring a unique perspective. We are not attorneys and advocates, and also we are not school districts. So we are kind of in that liminal space in between. And so we're really hoping that that's going to provide something of great value to families and the professionals who serve them. Next slide. And the next slide too. So acronym review, just so everyone's on the same page. If I say, or if you read LEA, local education agency, that means a public school or a public district. Next slide. IDEA or IDEA, Individuals with Disabilities Educational Act. This is really a reference to federal special education law. It also appears within this document. Individualized Education Program, the IEP, is the document that confirms, documents the public schools offer of a free, appropriate public education, which is, of course, the next one, FAPE. Free, appropriate public education actually means that a school conducted appropriate assessment, we'll talk about that, afforded parent participation, we'll talk about that, developed an IEP, We mostly talk about that in our program's IEP Basics and Beyond the Basics. FAPE also means that the public school identified the least restrictive environment and observed the procedural safeguards, which is why we're all here today. So just a few, I guess, ideas grande, big ideas, is that, next slide, Joe. The first one is to know that the procedural safeguards vary from state to state. This QR code will take you to California's most recent version. On the left of your screen is the English. On the right of your screen will take you to the Spanish language translation. This is the most recent version, updated in June of 2022. And I say that they vary from state to state in so much as just because you know California's does not mean you can move to Illinois and expect the exact same kinds of safeguards. Many will be the same because many are federal, but there are always little nuances that I would really encourage you when you land in a different location. Please make sure that you get the procedural safeguards from that locality. So, what are procedural safeguards? Big definition. They are parental rights and responsibilities. They also review a school's obligation. And I'm not sure what it says of the LEA. So, school's obligation, period. And then procedural safeguards provide a framework for preventing and resolving disagreements. Big idea. Procedural safeguards are parent rights and responsibilities until the student turns 18. Then, for the vast majority of students, they will become the student's rights and responsibilities unless the student transfers them to a parent or unless a court assigns those rights to someone other than the student. In California, this is typically accomplished through a process called conservatorship. The other thing is that there are ways of having supported decision-making in the state of California, and certainly we can talk about that in the Q&A, that there are ways around the student transferring them to you outside of conservatorship. Okay, procedural safeguards cover special education, rights, responsibilities, okay? But it doesn't include all the special education law that's out there, both federal and state. The other thing that I like to remind families is local board policies, local boards, administrative regulations, and your school's labor agreements can also kind of affect the way that it will feel as you go through an IEP process. Okay, this is the big change. We are aligned with our procedural safeguards and our IEP basics. So you will see that throughout this presentation, we are going to, again, reinforce the idea that we move through an IEP process. And so there are various entry points for families to participate and to exercise procedural safeguards. So just a little note, you'll see in the corner of a slide, a little blue shape with a page number. That page number is intended to refer you back to the procedural safeguards. One warning, I did not have time to cross-check our Spanish and Chinese interpretations that the pages exactly paginate with English. So it'll be near for our Spanish listeners, near, maybe not precise. So we're going to start with referral. Upon referral, these procedural safeguards really kind of take effect for a family. As a parent of a prospective student, you still have procedural safeguards. And so the next slide is going to really define procedural well, it's not defining yet. On page 1 of the procedural safeguards, it starts with telling you all the times that a school needs to provide those procedural safeguards to the family. It needs to be provided at least once a year. In addition, it needs to be provided to a family when they ask for them, their first referral for assessment, with each assessment plan, upon receipt of the first state complaint in a year, upon receipt of the first due process request in a year, and also it needs to be provided if there is a decision to make a disciplinary removal from the student's placement. So notice of procedural safeguards. You'll see in the corner again, page 1 and 2, and then also I pulled something from IDEA into this slide. So parents have the right to receive a copy of the notice of procedural safeguards in their primary language or mode of communication. They have a right to receive these copies at prescribed instances that we just covered, as well as annually. It is the parent's responsibility, and you are going to hear me say this over and over through this presentation, to be a good steward of your child's educational rights. This includes knowing when the procedural safeguard might require navigation by a skilled party. Parts of these are very much parent-friendly. Other parts take some technical expertise, and I will identify those as we go through. The school has a responsibility also, and their responsibility is usually the inverse of the family. For a right, we have a responsibility, and vice versa. So the LEA, or the school's responsibility, is to provide the document as indicated, to be available to explain procedures, and to direct the parent to other sources of information and help. And just kind of a reflection, we get these so often that sometimes families can feel a little like, been there, done that, heard it all, and like I can now wallpaper my whole house in this. The point, though, is that you really do learn to, as a family member, get help in understanding these procedural safeguards, which is hopefully why you're here today. So as far as getting help, you have the right to obtain information about your child's special education, as well as assistance in understanding the procedural safeguards. This also implies a responsibility for the family member to ask questions, to seek out help. It's not enough to say, oh, the school needs to tell me. Not mind readers. Sometimes you need to ask, hey, I read this. I don't know how this applies. I don't know what the process in my school is for making these requests. Can you help me? School will provide answers and information and or direct parents to other sources of assistance. The sources of information and assistance will look very much like kind of a chain of command that's embedded in the procedural safeguards. So kind of that idea of starting local, and the most local is talking to your child's teacher, the person that has the most contact with your student, or the principal of the site, excuse me. Then every school has a special education local plan area in the state of California. So you can also kind of bring the concerns to a district or its SELPA. But not always the same. We have a couple of districts that are their own SELPAs. So those are San Diego Unified School District and Poway. The rest are usually part of a multi-district SELPA. So those are both options to go to. You can also contact a Family Empowerment Center. EFRC is your local one, or a Parent Training and Information Center. You can also make inquiries to your county's Office of Education or to the California Department of Education, or in certain circumstances, to the U.S. Department of Education. And then this slide really covers specific low incidence disabilities, and this is state special schools. So the state school for the deaf, there's 2, serve from infancy to age 21 years. The California School for the Blind serves students that are ages 5 through 21 years. These schools provide a variety of services to people who are to youth who are deaf, hard of hearing, blind, visually impaired, and deafblind. Those services, not just residential and day school programs, those services can also be in the form of assessments and technical assistance to other service providers. So now we're in assessment. Parents' role in assessment, parent to parent, is primarily around the idea of consenting, because the school needs to get your consent in order to conduct its initial assessment for eligibility. As I always say, this is separate and apart. When you consent to initial assessment, you are not consenting to anything other than initial assessment. You are not committing to your child being placed in special education. That is a separate consent process. So, parental consent. And as again, I reiterate, there's a consent to assessment, a separate consent to services. Parent responsibility that's implied is that your consent starts the timeline. It also, your consent will determine the onset of service delivery. The school's responsibility is to ensure informed consent, and that's usually done by letting you know, we intend to assess your child. We intend to assess your child in these specific areas. We respect the parent's role in decision making, and so they're going to abide by that required consent. You'll see I skipped to 5 because we're in consent land. So when we talk about consent, you do have the right as a parent to revoke consent. You'll notice I put parent parentheses child because another time that sometimes consent is revoked is when a student turns 18 and has their own self-determination around their consent to services in special education. So change your mind, revoke consent. Usually you will write this down. You will send an email that says, I am revoking consent. This is kind of a big deal. So this would be another time that really understanding the implications of changing your mind is important. It stops some procedures, and you'll see those on the next page, but it also discontinues special education. So you may be stopping something that you may be stopping a procedural safeguard from taking effect, but you will also be stopping the service. So those go together. The school has a responsibility also. Upon notification that the rights holder is revoking consent, that is to say, taking away consent, the school needs to issue what is called a prior written notice, or PWN. At that time, they no longer will convene IEP meetings. They will not try to pursue agreement through other procedural safeguards, and they will have no further obligation to provide a free, appropriate public education to the student. But they do have to send a letter saying we will be stopping services, and then all of these things also stop. I also just want to make a note in that little starburst. This comes up sometimes. Families are like, well, we've changed our consent, and so then they want to go in, ask the school to remove all references to special education because our child's no longer in special education. It does not work that way. That would be, we can't revise history. We can't change what was delivered. We can't pretend that didn't get delivered. But going forward, the student would no longer be identified as a student with a disability, with an IEP. Sorry. Okay. When a parent does not provide consent, so you can see handy table. You can also read page 5 in paragraph form, but I think this might be a little easier. So if a parent does not consent to the initial assessment, and that they specifically say, I'm not consenting to this assessment, the school may pursue the initial assessment by utilizing what's called due process, which is a formal legal procedure. The next line says, if the parent does not consent to an initial assessment and that they do not respond to the request, the exact same thing happens. The school may pursue initial assessment by utilizing due process. So I'm going to emphasize a couple of things. One is that the word may means it's up to the school's discretion. They may not. Okay. The other thing that I want to highlight here, and I'll probably mention again, is how many times a parent rejecting like not giving consent because they disagree, mirrors the effect of a parent just not responding at all, just not making a decision. That it feels the same often to the school personnel. So something just to keep in mind. If a parent does not consent to the initiation of services, then the school must not provide special education and shall not seek to do so through due process. That is a legal formal procedure. So again, we did may. May gives that idea of some options. Must, shall, those are non-negotiable. The school doesn't get to decide. The school has to follow this procedure. Okay. So in this case, initiation of services, if you do not agree as the parent to that initial initiation of services, that initial identification of eligibility, then the school district must not provide services, must not identify your child as a person with an IEP, and must not take further action against you in terms of the due process. If a parent does not consent to all components of the IEP, the school must implement those components to which the parent has consented without delay. Not defined beyond that, without delay. If a parent does not consent to a component of the IEP that the school believes is necessary, is critical to provide a free, appropriate public education for the student, then the school must initiate a due process hearing. So you can see there's like some flexibility and some not flexibility. If a parent does not consent to a reevaluation, so this sometimes is called a triennial review or eligibility review. So that's the every 3 years, we're going to reassess to see if the student is eligible still for special education. So if a parent does not consent to that reevaluation, and again, that's the idea that they've rejected the assessment, the school need only document reasonable measures to obtain parental consent. With no response, they may proceed with the reevaluation in the absence of parent consent. So speaking of absence of consent, now we're going to talk about the special circumstances of parental absence. And this happens for a variety of reasons. And I have termed this, the prior written notice does not call it a child's right, but in my head, it's really the right for the child to have an adult other than a school employee making decisions on behalf of that student. So this notice of procedural safeguards portion really puts the responsibility and onus on the school to identify and appoint an adult who will assume the educational decision-making on behalf of a student when a parent cannot be located or when a student is unaccompanied. So now we're at prior written notice, and you already saw PWN earlier, but now we're going to really dig into the details. And one of the most familiar kinds of prior written notice happens to be the assessment plan that we just kind of referenced. So it is required to be provided within 15 days of a written request for evaluation. You have, you as a parent, have at least 15 days to consider an assessment plan. It needs to be provided in the family's primary language or mode of communication unless it is not feasible to do so. And so what is a prior written notice? It's a requirement that a school provide advance written notice when it intends to propose a change or refuses to initiate a change in the identification, assessment, or educational placement of the child, or when it's proposing a change or refusing a change to the provision of a free, appropriate public education. So, parent right is to receive information from the school in advance of a change in the student's special education taking effect. It gives an interval in which a parent can exercise some of the other procedural safeguards that we're going to be reviewing prior to the impact of the change. Parent responsibility is to actually review and attempt to understand the prior written notice. And the school's responsibility is to provide information in advance about a planned change in the student's special education. And this can come in a certified letter. It can come in email. It can come in a variety of forms. It can, from a parent perspective, look scary or official. And just parent to parent, I used to beg schools to give me prior written notice, whether it was for my own child or someone I was supporting. It is such a good source of information, and sometimes it's an opportunity to really have a productive conversation. So parent to parent, please, and I'll reinforce this later, please consider this an opportunity for clarification and perspective and information, not punitive process. So the required components of a prior written notice include some pretty lengthy, complex kinds of information. Number one, the school needs to clearly describe the actions proposed or refused by the school. It can be one action, it could be multiple actions. It needs to explain why the action is being proposed or refused. It needs to, number three, refer to assessment procedures, records, or reports that the school used as the foundation for the action being proposed or refused. It has to include a reminder that parents have protection under the procedural safeguards. It needs to include sources for help for the parent in understanding their procedural safeguards. It needs to include other options that the IEP team considered and why those were rejected. And it needs to disclose any other factor relevant to the action proposed or refused. So this is an incredibly valuable document in that it has a lot of information in a format other than someone talking to you, often in front of other people, all looking at you. So from a parent perspective, it does give you a different modality. It might give you more information or more complete information, and in a way that is very logical. So again, it can be lengthy, it can be official looking, but overall it is really there for as a protection for the family. So we're going to talk about non-discriminatory assessment, and literally going to read this slide, which is that the non-discriminatory assessment needs to be given in the primary language or mode of communication of the student unless it is clearly not feasible. Not just not feasible, clearly not feasible. The non-discriminatory assessment would be age appropriate. It would be not biased in favor of or against any group, and that could be by race, by culture, by sex, all of the things. And it needs to be administered and interpreted by an appropriately qualified party. And so, yes, there are rights and responsibilities throughout the assessment process. They are both explicitly stated and a few that are tacitly stated. So I am trying to pull them out so that families can understand the expectations and how their participation is very much valued. So parental rights. The child needs to be assessed in all areas of suspected disability by an appropriately qualified party. Responsibilities. To sign the assessment plan, to give consent so that the process can go forward if they choose. Parent responsibility, if you've signed the assessment plan, is to actually make the student available for the assessment so that the assessment can be conducted within the timeline. It's also important that families provide information that's requested by the school team. To have a non-discriminatory, thorough assessment does rely on the parent as a provider of a lot of very valuable information and perspective about the student's history, the student's needs, etc. And this also is very important to note that the family needs to help disclose any recent evaluations that were conducted just to ensure the validity of any assessment tools that are being used. The school's responsibility is to use valid materials and procedures that are the most likely to yield accurate information, to avoid relying upon a single measure in the determination of eligibility, and to complete their assessment and convene that IEP team to develop an IEP if appropriate within the timeline. The timeline is typically 60 days, the kind of universal from the time the district receives written consent to the assessment plan, 60 days, and it excludes those calendar days where the district or the school is off calendar for greater than 5 days consecutively. So if your child is attending a private school, assessment is a right. So they also have the right to participate in a publicly funded special education program. They do not have the right, however, to receive an IEP, and there is not an associated obligation to provide a free, appropriate public education. Again, parental responsibilities look a lot like making the child available for assessment, supplying information to the assessors. Again, implied is the consent to the plan. And the school's responsibility, again, this is the public school's responsibility, is identification and assessment of private school students who may be eligible under IDEA for special education. Okay. And this refers to page 14. So now we're at independent educational assessment, often called IEEs, standing for Independent Educational Evaluation, but they had to go and change the acronym on me a little. This is an assessment that can be requested by a family to be conducted by someone who is not employed by the school, but who is funded or paid for by the school. So not a school district employee, but someone for whom public money is being used. This is totally different than an independent evaluation, which is when a person who is not a school employee but is not funded by the school is conducting an evaluation. And I'm going to give an example, like an independent evaluation that you bring to the team could be your child sees a physical therapist in a clinical model. You want the team to review those recommendations and consider them. So your health insurance is funding that assessment. So it isn't an educational assessment per se. The team needs to consider both IEEs or IEA kinds of assessment as well as independent evaluations, but the school does not have a mandate to accept those results or to incorporate all of their results and findings into an IEP. So it is one more source. Some folks look at an IEE or an independent educational assessment as kind of a second opinion that overrides the school district's evaluation, and that is not the case. It is another source of information that will be considered in the context of the first assessment that was conducted by the school. Because this is really important for families to understand, families and schools. I want to go through the rights and responsibilities associated. So parents have the right to disagree with some or all of the school's assessment of their student. The responsibility is to act, like visibly act, in advance of engaging for an outside evaluation. The school's responsibility is pretty significant, and that is they need to decide whether they are going to fund the parent's requested independent educational assessment or whether they are going to file to defend the appropriateness of the district assessment or school assessment. The school also has a responsibility to maintain and provide a list of local independent educational assessors. If the student was observed as part of the school's assessment, then the school must allow the independent educational evaluator to observe the student. If there is a prospective placement being proposed, Ooh, that's a lot of P's. The school also must allow the independent educational evaluator to view that same prospective placement. So just kind of fairness, making sure everybody's getting to see the same sorts of things. And because this is so critical, we're going to try an infographic, and this is intended to be very much in an order. So the district always does its assessment. It gets to pick the assessment it chooses to do. So it gets to do it first, and it gets to do the assessment it chooses. If the parent disagrees, then the parent can request an IEE or an independent educational assessment. The school can and often does ask for more information about the nature of the disagreement. Like, what did we do wrong? What is your concern? Those kinds of questions. Absolutely allowed to do that. And my encouragement as a non-attorney is that you answer in layperson terms. You're not a speech person. You're not going to pick it apart, but you might have, big picture disagreement. Then the district or the school gets to think about its decision point. So that's why it's the fork in the road. It can either fund or file. Okay, no timeline is listed. So it's not like the district has 5 days to make that decision. It's they must fund or file, not days listed. And I saw a question in the chat that I'm going to answer right now. Just a clarifying question. Did I say that even if you get an IEE, the district is not required to actually consider the results? No, I did not say that. I said the district is required to consider the results. They are not required to accept all the results and put them all into their IEP document. So considering means that they are listening, they are asking questions, they are putting that as a data source. They are taking in the information, but again, it's still a team decision. It's not the assessor coming in and overriding all other information that exists about the team. And we can cover that a little bit more later, but hopefully that addressed that question. How's everybody doing? Hopefully we're okay. We're doing very well. Just for the record, we are almost halfway done. So now we're in the IEP meeting. So first of all, parents are invited. They're needed. They are a critical member without whom we can't have an IEP meeting. They have the opportunity to share concerns about the student's education during the IEP process, and they are members of the team that determine eligibility and placement. And so Maria's question about like that idea of considering, it very much mirrors how parent input is. So I am involved even if the school, like if I've shared concerns, if I've had an opportunity to raise questions and answer questions and to give input, I've still given input even if when I ask the district to consider a request, they say no. Okay, so it's not necessarily, it's just like in an IEE, just my saying it doesn't mean they have to write everything I say down into the document. So we are at educational records. So I could do an entire hour plus training on what are and what aren't educational records, but we're not going to do that because I still have lots of slides to go. So in short, your rights are to inspect, review, and receive a copy of pupil records. You can request orally or in writing. The star, the bold are hints as to which way I would recommend as a non-attorney that you make requests for educational records. And then the school responsibility is to make available the records within 5 business days of the request. We have an audio recording right. So the parent has the right to make the audio recording, and they also have the right to determine whether an audio recording may be made at all. You have the right. Some recommend always recording. Some only record certain kinds of meetings for certain reasons. the parent needs to provide the school with at least 24 hours advance notice of the parent's intention to make an audio recording of the meeting. When a parent records, chances are very high that that's establishing a record, and so the school also needs to make an audio recording and maintain it with pupil records. That's if the parent chooses to record the meeting. If the parent is not recording, the school may request the opportunity to make a recording, and if the parent declines, the school must honor the parent's preference and not record. So, parent to parent, I don't think there's any need to play mind games. I encourage people, the minute you know you're going to make the recording, that you would like to record the meeting, let the school know so that they can be prepared. I don't like the games. So if you're going to record, say I'm going to record, and just do it. It doesn't need to be a big deal. Okay, parents' role in decision making, because now the IEP we've had the IEP. There's precious little discussion in the procedural safeguards about the actual IEP meeting. But now this is where we kind of come alive. So the school district or the school makes the offer of an IEP, and then the parent responds to the offer. So we have another handy infographic. It's so glamorous. Woo! So this is kind of a visual representation of the process by which a parent goes from being a member of the IEP team with everyone else sitting around the table where we're making the IEP to the responsibilities at the time when the administrative designee concludes that the district has fulfilled its obligations and is prepared to make an offer of a free, appropriate public education. At that time, the administrative designee is saying, here is our offer, it's presented, and then the parent or rights holder has the opportunity to respond. So everybody's on the team until decision time, and then there is a formal giving. And so just to kind of help clarify, member of a team to decider. Okay. So first we're going to look at a pretty significant kind of decision-making point. So if there was ever a time that somebody might want to have their IEP recording organized in advance and being recorded by both parties, this is that kind of meeting. So part one, it's implied that as a parent, you have the right to make decisions about your child's education, including the where your child is receiving services. Parent responsibilities, again, this is one of those bolds, like knowing when you need help in exercising procedural safeguards. Parent, it is your responsibility to ensure the possibility for eventual reimbursement if that is something that you want. Number one, you need to make your child available for assessment upon notice that you are going to remove your child from public school. And you must give the public school, and it's sometimes called 10-day notice, but you need to give the school notice that you are rejecting the placement that is being proposed by the school. And you need to state your concerns about the placement, and you need to state clearly that you intend to enroll your child in a private school at public expense. Okay, non-negotiable. Just like the school district, it's kind of the mirror of the prior written notice that a school needs to provide a parent, is that the parent has this obligation if they are seeking reimbursement ever. So this can occur one of two ways. It can occur during that IEP meeting prior to the student being removed from school, or it can occur in writing at least 10 business days before the student is removed from the public school. Okay. The school's responsibility is basically to provide a free, appropriate public education to students with disabilities who are enrolled in public school. It sounds simple, but we go to part two. So, parent has the right to seek reimbursement under certain conditions. And again, there's a reason I'm putting this in bright blue. which is being knowledgeable about when procedural safeguards may require support and assistance by someone who is more skilled than me. So a school responsibility is, this is my words, promoting conditions wherein a parent can provide that appropriate 10-day notice. So the way that the procedural safeguards on pages 14 and 15 put it is, if a parent fails to provide written notice to the school for the following reasons, then reimbursement must not be reduced or denied pending other legal proceedings. So if the school prevented provision of notice, if the school didn't give a copy of the procedural safeguards or otherwise failed to inform the family of the requirement, if providing notice would have resulted or was likely to result in the child's physical harm or serious emotional harm, or if illiteracy or inability to write in English prevented the parent from providing notice. So I'm going to put that in my translation, which is, this is a time to audio record a meeting. The school really needs to let you speak about your concerns and to help, like, we hear you disagree. Why? Do you intend? Like, to hear that piece, not to cut the parent off. That would be a way of preventing provision of notice. The responsibility to have a safe school is implied, and this really highlights the importance of interpretation and translation being available to families. Okay, next, please. When you disagree about your child's proposed IEP, you really have, this is 4 basic options: discussion, negotiation, mediation, and litigation. And you see within 2 years of the dispute. Discussion, for me, is continuing to work with the IEP team. Like, you can disagree and continue to meet, you can continue to, take in more information, more data, more observations, like get more information. That is a possibility. I'm calling negotiation the alternative dispute resolution process, even though sometimes it includes a more formalized mediation option. It is still like that kind of lower level, non-adversarial, collegial discussion. And to do that, you would be talking to your local school's ADR team, alternative dispute resolution team. Number 3, mediation. This is where you're thinking of either a pre-hearing mediation conference or requesting mediation only. That's a special kind of request from the Office of Administrative Hearings. We're going to talk about more in a few slides. And then litigation is really when we're thinking about filing a request for a due process hearing. That is, again, a formal legal proceeding. And first, we're going to talk a little bit about ADR. This is the space that Joe and I think some others on this call occupy. And this is really thinking how to prevent and resolve conflict at a low level, trying to catch it before it becomes a significant conflict. So this involves a less adversarial process. It is always voluntary for both parties. Of the formal options for resolution, this is the least formal. It is no cost to the family. It may not be used to delay your right to a due process hearing. And by that, it means that a school cannot require you to go through ADR in order to ask for a due process hearing. The outcomes of ADR tend to be 3: resolution, no agreement, or continuing to negotiate and meet. Mediation, in our document, pages 8 and 9 talk about pre-hearing mediation conferences. This occurs prior to filing a request for a due process hearing. It is an informal way to resolve issues related to eligibility, assessment, or educational placement, or to a free and appropriate public education. Specifically, non-attorney representatives are allowed during mediation, at least according to the procedural safeguards. And again, be a steward of your child's educational rights. Only you know what your skill set is as far as navigating a mediation in the absence of other support. So parents have the right to request resolution of issues in a non-adversarial manner. They to also do that and be retaining the option of filing for a due process hearing if the matter is not resolved. And they have the right to be accompanied by a non-attorney representative. The parent's responsibility, because there are, file your request for mediation with the Office of Administrative Hearings, OAH, and provide the school with a copy of the request at the same time as you file it with the Office of Administrative Hearings. The state has a responsibility to schedule within 15 days of the receipt of the request for mediation, and to complete the mediation within 30 days, unless both parties agree to extend the timeline. And it needs to be convened at a time and place reasonably convenient to both parties. So now we're going to talk for a little bit about due process. Due process is a formal legal option with very real risks and outcomes. Again, not an attorney. I can read, but I cannot advise. So briefly, I'm going to go through the parental rights. I think before we even read the parent rights, I want to talk about, like, number one, you should be getting help. And two, realistically, I would not expect you to rely on this video or this Zoom to remember all the rights. So we're going to go quickly. And litigation really occurs when the two parties cannot find a middle ground and needs this external party to decide for them. This is super risky. Joe, we can even go back to the previous slide. Super risky because neither party, neither the school nor the family, have control over what an administrative law judge could decide on a given day. And this also implies that a family is in a very adversarial position with the school district. There's money, there's reputation, there's credibility, there's control that are all at issue when we're talking about due process. So now we can go to the next slide. In brief, parents have a right to a fair, impartial administrative hearing before a person who is knowledgeable of special education law. They have the right to be accompanied by or advised by an attorney or advocate knowledgeable of children with disabilities and special education law. They have the right to present evidence, written arguments, and oral arguments. They have the right to confront, cross-examine, and require witnesses to be present. They have the right to receive a written or verbatim record of the hearing, including findings of fact and decisions. They have the right to decide to have the child present or not. They have the right to decide whether the hearing is open or closed to the public. They have the right to receive exhibits and witness lists, including the description of the testimony that is expected 5 days before the hearing. They have the right to be informed by the other party of issues in a proposed resolution at least 10 calendar days before the hearing. They have a right to an interpreter. They have the right to request an extension of the hearing timeline, to have a mediation conference at any time during the hearing, and they have the right to receive notice from the opposing party at least 10 days before the hearing that the opposing party will be represented by an attorney. With this comes great responsibility. Parents will have some of the same expectations because this is a legal process. So parents, you need to file a written, complete request for due process hearing that includes the basic components, and those are outlined in the documents that you'll see. 2, you need to provide a copy of that request to the other party at the same time that you are filing. You have to inform the other party if you will be represented by an attorney no later than the 10th day before the hearing. And you need to provide witnesses, witness list, the area of testimony, as well as all exhibits, at least 5 business days before the hearing. And then we have lots of public agency requirements. The school, so the other party, within 15 days of receiving the notice of a due process hearing request, needs to convene what's called a resolution session. If the parent is accompanied by an attorney, then the school gets to bring an attorney too. Otherwise, no attorneys. And the only time a resolution session is not required is if both the parent and the school agree in writing to waive this meeting. The school needs to inform the parent if they will be represented by an attorney at least 10 days before the hearing. They need to inform the parent of issues and proposed resolution at least 10 calendar days before the hearing. And they need to provide exhibits, witness list, area of testimony at least 5 business days before the hearing. And the state's responsibility within this process is to assign an administrative law judge, to do scheduling, to provide interpretation if needed, and to arrange that there is a final binding decision rendered. If you don't pay any attention to any other slide, pay attention here. Your ability as a parent to recover attorney's fees can be reduced or denied for any of these reasons. And so this is why I keep saying, know when you need help. And I'm going to preface this with, if you have an attorney come to IEP meetings that are not part of a hearing or an order, those are not going to be reimbursed. Those don't count as attorney's fees. Attorney's fees have to do with the resolution of conflict, not just attending IEP meetings. So, number one, if you unreasonably delay the final resolution of the controversy, your right to recover attorney's fees can be reduced or denied. If your attorney's hourly fees exceed the prevailing community rate for comparably able attorneys, again, say it with me, attorney's fees can be reduced. If the time spent on the case or the legal services provided are deemed excessive, if your attorney did not provide the other party appropriate information in the due process request notice, so that very first filing, if that is not sufficient, again, if they're delaying the timeline, if they're not providing what would be expected of professional representation, those can all reduce attorney's fees. Lastly, all the fees are in peril if you reject a reasonable settlement offer made by the school 10 days before the hearing, and if the hearing decision is not more favorable than that offer. So this is basically like you risk any of those things. The next slide talks about important topics to discuss with your attorney. This is my big hint that way out of my league. So number one is stay put placement. Family and
Maura, we're having some connection issue with you. Not sure if you can hear me. We have some connection issue. Maybe you want to turn your camera off. Are you there, Maura? And you're back.
Okay, thanks. I apologize. I won't say the name of my internet provider. Anyway, so should I start with stay put?
Yes.
Okay. So important topics to discuss with your attorney. One of them is stay put placement. And so some families have been known to say, my child is in a stay put. Upon discussion, we find out that no, they have not actually requested that administrative or judicial proceeding yet. So really the placement remains unless both parties agree to change, but that happens once a family is entered into mediation or due process. Another topic is that there is the possibility of appealing a final binding decision in either state or federal court. This needs to happen within 90 days of the decision. And for to a prevailing party, So,
Maura, we're having a little bit of connection issue, so maybe you want to try to turn off your camera. We'll see if
okay.
that's a little better. And I will advance the slide now.
Let me know if you cannot hear me or if you can hear me. Can you hear me, Joe? Can you hear me? Joe, can you hear me?
Yes, I can hear you. Yes, I
Okay,
can.
let's try this. I'm shutting things off and seeing if that helps. Okay, so we're at the parent's role during implementation. And this is going to really look at covering 3 kinds of conflicts that can come up between kind of the IEP process and the next one. So one of those is discipline. One is failure on the school's part to implement, or at least I should say the allegation that the school is not implementing. And the third is discrimination. The violation of procedural safeguards and or special education, federal or state law, those are also things that possibly might need to be addressed. So we're going to start with a quick review of some discipline definitions. So the first is just making sure everyone on the call knows a suspension is a temporary removal from the instructional setting that's in a student's IEP, whereas expulsion is that permanent removal of a student from the instructional setting that's contained within their IEP. These are referenced in the procedural safeguards. So functional behavior assessment is a specific assessment to determine the function of a student's problem behaviors, and it usually utilizes observation and data collection by a behavior specialist across many settings and dates. A behavior intervention plan, or BIP, is sometimes called, is a component of an IEP in which the school identifies a target behavior or behaviors and develops a plan to replace the behavior with a functionally equivalent replacement behavior. And manifestation determination review is a special type of IEP meeting. It is convened on behalf of a student with disabilities who has experienced disciplinary sanction that affects their placement. The purpose of the meeting is to really just answer 2 questions. One, is the student's behavior directly and substantially related to the student's disability? And 2, is the student's behavior directly and substantially related to the school failing to implement the student's IEP? And then that brings us to interim alternative educational settings. And this is under certain circumstances, a school district can place a student in a different placement unilaterally for up to 45 days. IAES is what you may hear this placement called. So let's review parent rights and responsibilities around school discipline. You have the right to be invited to participate on an IEP team, including the one that is a manifestation determination, with all your usual procedural safeguards, making recordings of the meeting, looking at records, etc. Your responsibility, again, highlighted, knowing when you need help is your responsibility. The school has a responsibility to convene this special IEP meeting called a manifestation determination when a student has been removed from his or her current placement for 10 school days in the same school year. So they don't have to be, doesn't have to be one 10-day suspension. It could be lots of little suspensions that tally up to 10 days. So after the student's removal for 10 school days, including any subsequent removals, the school has an obligation to provide services to ensure participation in general education and student continuing to make progress on goals. The school also has the requirement to, as appropriate, conduct a functional behavior assessment and or develop or modify a behavior intervention plan and or propose additional assessments. So this slide is basically what happens when a school says it implemented the IEP with 100% fidelity and says that the child's disability is not substantially and directly related to the student's behavior that is the cause for the discipline. This can be an emergent situation because that very much can mean that the student is facing continuing impact on their placement. And so there is a special kind of fast track due process option, which is called expedited due process. So the parent does have the right to request an expedited due process hearing. It needs to occur within 20 school days of the date of request, which is really wicked fast. The parent responsibility, again, be a steward of your child's educational rights. The school responsibility is that the school may take disciplinary action, like expulsion, in the same manner as it would for a student without a disability, only if the IEP team concludes that the misconduct was not a manifestation of the student's disability and that all components of the IEP had been implemented. When this happens, the school does also have a responsibility to identify an IAES if necessary, in order to continue to provide a free, appropriate public education for the student. So let's say we're going to kind of change gears. We're going to take a big breath after the discipline. And we're going to think about, let's say that your child has a signed IEP that you are reasonably satisfied with, but you learn that there is some aspect of the IEP that is not being implemented. So you have a couple of options aside from talking to the team and meeting with the IEP team. You can file a local complaint with your local education agency. So this is usually called a uniform complaint. And then you also, within 1 year, could file a state complaint with your state education agency. And in our case, that's the California Department of Education. Let's go through what a state complaint procedure looks like. You have the right to file a complaint with the California Department of Education. You will cooperate, I guess this is really more of a responsibility, to cooperate with investigators and respond to requests for additional documents. Again, being a steward of your child's educational rights. And your responsibilities also include specifying at least one allegation of a violation of federal or state special education laws that occurred within 1 year of the filing date. Just like in due process requests, you need to also forward a copy to the school district at the same time that you are providing this to the California Department of Education. Under state complaint procedures, the local agency needs to respond to the complaint, is expected to provide access to the records and cooperate with investigators. And in this case, a state agency will have a responsibility to serve as the fact finder, investigating the complaint and usually making a determination within 60 days, usually. They will issue a finding and, if appropriate, corrective action or actions. So the next kind of scenario is if you believe that there has been a violation of civil rights. That is, that your child has been discriminated against on the basis of disability or other protected class. You can file a local complaint, local meaning uniform complaint, with your local school, or you may file a federal complaint with the Office of Civil Rights, or OCR. That needs to happen within 180 days unless you have evidence that you've been trying to resolve it through the local complaint process. Then it ended a little bit with evidence of that effort to resolve at a lower level. So now we're at parent-to-parent tips. Woohoo! And I'm going to try to put my camera back on and see if that'll work. I miss seeing you all. Okay, so parent to parent. Joe, are you hearing me? Okay, thank you.
Yes.
Okay, parent-to-parent tips. It got quiet. Okay, tip number 1 is that documentation is critical. Always, always, always follow up on an oral request in writing. And the kind of corollary to this is that the email that you send today out of anger, fear, frustration may not look awesome later, and that in-person conversations may not be your friend. So always having like that paper trail is really important. Tip 2 is just that recap, that the prior written notice, even though it looks scary, it can be useful. And just to keep in mind that it means the school is taking your request seriously and it is following the law. So that's refreshing and good, right? Tip 3, record keeping, do it. If you do eventually need assistance with a particular matter, being able to produce a chronological summary is really crucial. Things that you might need in the future and might want to think about keeping are IEPs that are signed, including those drafts as the IEP process is unfolding, assessment plans, assessment reports, including school, independent, and independent educational assessments if you have those. Any and all prior written notices, disciplinary records, suspension notices, incident reports, and/or investigation reports, particularly for discipline matters, progress reports and report cards, as well as statewide testing, any settlement or mediation agreements, emails about a particular issue between school personnel and family, and then audio recordings of IEP meetings, only if you've given notice and recorded the meeting. Okay, number 4, parent tip, do your best to keep emotions in check. And I say that as somebody who might have let my emotions not be in check sometimes in the past. Email and IEP recordings, every one of them becomes potentially an exhibit in a due process hearing. So you don't want evidence that you acted like a jerk. You want to look reasonable and credible. And if you have to send an email, if you cannot not send, then send it to yourself or send it to a family member or friend first. Seek out parent workshops. Number 5, this can be specific to the IEP process, to understanding acronyms, to anything else that affects your child and family. And along with that, being able to ask for parent counseling and training to assist you in your understanding of your child's disability, of child development, or to help support the implementation of the IEP. If there's special skills that you need to develop, those are all things that the IEP team could discuss helping you with. And then our last tip is you are not alone. It's also, please consider obtaining assistance with the following kinds of matters that kind of go beyond a non-attorney assisting you. And then our next slide is some resources, just to kind of clarify where you can get more information about the things we've discussed. So the first one is our frequently recommended links: California Department of Education, Disability Rights California, and then the Department of Governmental Services website. And those are the folks that kind of host the Office of Administrative Hearings for Special Education, does have a list of low-cost or free attorneys and advocates that you can review. We have more specific resources, like if you're military or if your child is a regional center client, there may be some other kinds of advocacy available, and I invite you to reach out to us after this training. Next, I want you to know where to go to for technical assistance. They will help parents, districts, attorneys and advocates, agencies, and anyone else. They will help you understand procedural safeguards. So here's how to contact them. You heard me say during this training that there are local complaint procedures. So this is every single local educational agency should have information on how to submit its own uniform complaint. Every SELPA, which is the Special Education Local Plan area, should have information on how you can access its alternative dispute resolution process. Joe and I work closely with many of the ADR teams, and that's usually where we start, is like, let's connect with someone who knows the school, knows the SELPA well, and can really is really expert on kind of taking the conflict down and really identifying issues. If you need assistance locating either of those resources, please contact me or Joe, and we are happy to find those for you. If you choose to file a state complaint of noncompliance, these are some recommended both English and Spanish resources. If you need to learn more about the Office of Administrative Hearings, Due Process, and Mediation, here are the request forms on the next slide. And then I did mention OCR complaints, so the Office of Civil Rights. For complaints of discrimination, here is more information about how to proceed. And then our last recorded slide is that we are a family empowerment center. We made the notice of procedural safeguards. Pages